questions, please type in the chat box and we will discuss them during the Q&A session later. Please allow me to introduce our speaker, Ms. Tan Po Yi. She's the Deputy of Learning and Development of Hang Hong and Quek. She provides regular updates in the empowerment section of HHQ website, which showcase weekly legal news, HHQ CPD, HHQ case and facts, and newsletters. She was active in litigation matters. She possesses full solicitor skill set and was second chair in her previous litigation work. She has also appeared as a counsel representing a landowner in land acquisition matters to seek for fair compensation. So please join me to welcome our speaker, Ms. Tan Po Yi.
Thank you, Iti. Good morning, everyone. Okay. Today, I would like to share my experience and with foreclosure and eviction. Next slide. Today, I will be dealing with key points. Our scope of sharing will be High Court and Land Office foreclosure, the process, and what happens on auction day, and post-auction process. Next slide. So what is foreclosure? So foreclosure is a process where the banks proceed to legal action to obtain an order for sale, a court order to sell off the security, to enforce the security that is held on the default of the borrower, the charger, to service his loans. So the security is usually in form of a charge. For High Court and Land Office, there's a usual charge. So this is a right in accordance with it is accorded to the chargee under section 256 of the National Code. This for registry, and also under section 260A of the National Code. This is for Land Office charge. So when the borrower charges his own property to the bank as security, this is his first party charge, okay? Because he charges his own property as security. Okay. But a borrower can also charge property that does not belong to him, but belongs to his family members, such as his parents or his siblings. Okay, so that is a third party charge. Okay, it's obviously being accepted as security for banks. So banks, borrower has the responsibility under the charge, under the loan agreement that is signed, that he has to service the loan, okay, installment timely. So where there is a default, that is where the legal action that is referred to as foreclosure that will kickstart. Next slide. Okay, so what happens when the borrowers fail to service their monthly installments? The notice, first will be notice of demand will be issued, okay, to the borrower, and also the charger, the charge is a third party charge, okay, if they fail to pay the monthly installments. Okay. Usually when there is 3 months of consecutive months of default, then this will be followed by notice of demand. Perhaps the first 2 months, the banks will start calling the borrowers to regularize their installments. It could be because they have forgotten to regularize. Okay, only when there's usually 3 months consecutive, then only they will be followed by notice of demand. Okay. So it's when notice of demand is being not being complied. Okay, then you have this call. Okay, that's the next stage. So it's a third party charge. It is important that the borrower, the charger and the borrower be notified. If there's a guarantor also, the guarantor needs to be notified. You need to demand from the guarantor. So when a borrower fails to pay up the earnest, then bank will instruct the lawyers to issue a notice of recall. Okay, some may refer that as notice of termination, where by issuance of this notice of recall, all the sums outstanding will be due. When a borrower fails to comply with the notice of recall and the loan has been outstanding for at least 1 month, then the banks will instruct the lawyers in the next stage will be the issuance of Form 16B. And this 16B will be issued to the charger. It can be copied to the borrower if there's a third party. So Form 16B is a statutory notice described under Section 254 of the National Land Code. So this is a must. It's a statutory notice. The form, the wordings there. Okay, you just have to adjust it accordingly. Okay, but issuance of 16B notice to the charger will demand you have to correct what is stated, what is the outstanding sum. Okay, this is a condition decision. Okay, to obtain an order for sale, okay, either from court or from land office. Then the sum demanded in 16B must have been due at least 1 month. You don't issue, then you leave 14 days notice of recall before that, and straight away you issue a 16B because that's short of 1 month. Okay, so at least 1 month the loan has been outstanding, then only you issue a 16B. Okay, so this 16B, when you issue, you have to state specifically, okay, what are the breach. It's very important. Okay, it's like a charge. Then you have to, like criminal charge, you have to state clearly what is the charge. Okay, what is the default under clause 1 of the charge. So it's important to be specific when you issue 16B. Okay, and after issuance of 16B, you have to be properly served. Next slide, please. Okay, so you have to give another 1 month notice, okay, to remedy the default stated in 16B. Okay, that's also another important note. 16B cannot be mixed up with 16B. When to issue 16B and when to issue 16B. Okay, both are prescribed notices under the National Land Code. So 16B is used where the loan is payable by installment, such as your housing loan, okay, normally housing loan, home loan. 16E notice is issued for loan that is repayable by 1 lump sum. For example, your overdraft. You don't pay overdraft by installment, right? So when overdraft is due, overdrawn the limit, then you have to pay 1 lump sum. Okay, so issuance of the raw notice in will result in your application for order for sale to be rejected by court. It can amount to cost to the contract, which are discussed later. Okay, so after 16B, this is the where, okay, you determine high court foreclosure or land lease foreclosure. So I will go through the high court foreclosure first. So filing of originating summons. Okay, after 1 month due date from the failure to remedy the 16B notice, this will be followed by filing of originating summons. That's where you start the proceedings. Okay. So this is a provision accorded under rules 83, okay, and 28 of the rules of court 2412, the procedure process, what you need to do, what you need to file, the deadline on there. Okay. So the two provisions are to be read together with section 256 of the National Land Code. How does the chargee know, okay, when to apply to court and when to apply to land office for an order for sale? registry title, okay, the titles issued by to city and town lands, okay, and usually a land area exceeding 4 hectares stated as HSD will be usually as marked as HSD in the title. Okay, so that is where you go to high court. Okay, that's registry title. Whereas booking title, okay, is labeled as HSM. Okay, in the title. So if it's HSM, then you go to that office to get your order fulfilled. So after filing your originating summons, okay, you get a date, okay, a state copy of the originating summons, which you have to serve. Okay, service in terms, in accordance with the terms of charge. Usually, the charge itself or the loan agreement will provide for the mode of service. Okay, so if it provides for mode of service, you follow the mode of service. Usually by registered post, if you say by registered post, you begin good service, then you send by registered post. Okay, and produce the receipt of posting, to the posting accordingly. Okay, so validity of originating summons is also very important to note that on OS has a validity of 6 months and can be extended. So take note of the deadline, make sure that it's served within the time accordingly. Okay, so that comes to hearing. Okay, then we fix the hearing date. Before that, you will have to file a notice of appointment. Okay, to get that before the judge, the high court judge. Okay. Normally, this one will be foreclosure is in chambers matter. Okay, so it's not high court itself, but sometimes the court can call it into open court. Okay. So you file your notice of appointment, we call it NACOS. Okay. That is provided under Order 3 Rule 4 of the Rules of Court 2004. Okay. Where the hearing is adjourned and the defendant was absent from the hearing, plaintiff shall serve a written notice of adjournment hearing together with a copy of further affidavit on the defendant, not less than 2 days before the hearing. Okay, so hearing of the OS, apart from filing the NACOS, you have to file an affidavit to exhibit the bank statement, okay, of outstanding sum. That statement will show what is the loan sum, okay, what is the amount of payment made so far, what is the amount of installment, okay, amount outstanding as at the hearing date. So the bank has to calculate all that for you, for a lawyer, and you file it. Okay, affidavit is to be served on the charger with the defendant at least 2 clear days before the hearing date. Okay, on hearing of OS, the court shall grant an order for sale unless there is a cause to the contrary. Okay, that is provided under section 256 sub 3 of the National Land Code. So in regards to cause to the contrary, is already discussed in federal court decision in Laudilian against Bank Bank, landmark decision 1997. Okay, so where Gopal Sriram Justice has laid down. Okay, when granting order for sale, what would be amounting to the rule, to the contrary to the rule of law. So where the charge's title, okay, or interest in the charged property is divisible under section 340 sub 2 of the National Land Code. Is one of the circumstances, okay, or the charger fails to meet the condition precedent for making an order for sale. This is where one of the example is the issue wrong notice of 16D. It's because 16D is one of the conditions precedent to obtain an order for sale, or the 16D was not served, so you don't meet the condition precedent. That's where you do it will amount to a cost for the contrary, okay, and your OS order for sale will be refused. Okay, so once order was posting was obtained, okay, so that's where you have to file further, okay, to get the further direction of the court. So it's important to note that an order for sale is just an order that we set. There's no particulars of who an auction date will be fixed, but you have no direction as to the reserve price, auctioneer. Okay, so that's why you have to file the further direction by way of summons for direction. Your order for sale has to be sealed, okay? You can file your draft order accordingly and get it sealed, okay? And then serve on the charge of the defendant. Your summons for direction should be supported by affidavit in support, okay? Where your affidavit in support, the bank's affidavit in support, the charges affidavit in support should exhibit the valuation report, okay, of the property. So this is where the stage where this summons for direction. Next slide, please. The summons for direction is to ask for the following directions, okay, under section 2571 of the National Land Code. Okay, is to provide that the sale to be by public auction. Okay, so once it's ordered to be public auction, then you cannot withdraw and go for private auction. Okay, to fix an auction date. Okay, usually the first auction date that's fixed by the judge, by the time you file, is about 1 month away. You want 1 plus month. So the senior assistant registrar who got the summons for direction will fix another auction date. Okay, it is 2 years. And then you fix also direction that this auction to be fixed not less than 1 month from the order for sale, the order for direction, sorry, and to require the registrar to fix reserve price. This is where the registrar will have to refer to the valuation report, okay, to see what's the reserve price, to fix the reserve price. Require that the proclamation and the conditions of sale to be posted at the court's premises. Okay, you have to post it and to advertise it at least 7 days before the auction date. Okay, and also specify that the chargee bank, the plaintiff, to pay execution fee of 3% of the reserve price through e-court finance system by way of bank draft within 14 days of date of order for direction, and the receipt of payment to be filed in court through the finance system, okay, and require the chargee bank to deposit original title, is also very important, okay, and duplicate charge to the court by way of e-filing at least 7 days before the auction date. Next slide. Specify that no bidder shall be allowed to bid unless they possess, unless they deposit, not need to deposit the 10% of the reserve price to court before the bid. Okay. And also specify the interested bidder to register themselves through the e-legal portal, register online. Okay. And they also specify who bidder who registered to Lelong, okay, they must register themselves at least 1 day before the auction date. Next slide. Specify that the balance of the purchase price must be paid within 120 days from the date of auction. It's important to note that there is no extension. There will be no extension of time, okay, for court auction. Specify that where the balance of the purchase price is not paid within the 120 days, what happens? That the deposit will be forfeited and the property be fixed for fresh auction. Okay. This is provided under Section 267A of the National Code. They specify that all costs and expenses of the auction to be borne by the judge. Next slide. So upon granting, okay, the CCP will usually grant all these terms. Okay, upon granting this, then the court will take an auction date. They usually 1.5 months away, okay, from the date of the correction. So that's where you see the auctioneer will start to liaise with the chargee's lawyer, okay, to approve their draft proclamation of sale, the conditions of sale. So lawyers have to ensure that it is done, okay, as soon as possible. And the particulars of the proclamation of sale, okay, for auctioneer and chargee's lawyers, okay, to take note of the particulars of the title, okay, and the property, okay, through the title search and the valuation report. So the valuation report ensure that it's correctly done, it's accurately done. Okay. Okay, next slide. Okay, then refer to a court of appeal decision of in addition, okay, and then it's quite latest decision. Okay, the successful bidder claim against the bank for damages. Okay. On there's a discrepancy of the size of the property. It gets a smaller size when the proclamation states that the bigger size. Okay, so the bank could not use the excess raise basis, okay, for particulars of property. So the purchaser got that benefits. Okay, so it's important that the particulars of the property be stated correctly. Okay. And the chargee's lawyer to request from the chargee the original title. To request quickly after you get the direction, you quickly request for the original title and duplicate charge from the bank. Okay, they use some time to locate that. So you have to remember then to deposit that in the court at least 7 days before the auction date. So on auction day, okay, the due procedure by e-label, where auction conducted through the internet without physical presence of bidder. Okay, the successful bidder will be required to sign in, okay, to sign a contract of sale, okay, which is the proclamation of sale, okay, with the conditions of sale if successful. Okay. So important terms in your proclamation of sale that intending bidders, okay, for the auction on as is where is basis. The balance purchase price must be paid within 120 days. This is very, very important. Okay. Remember, there's no extension. Okay. So there's no extension of time and the apportionment of outlays. Okay. If they're represented by lawyer, if we get after right to auction, we get a copy of the apportionment, a copy of the outgoings for apportionment. If the auction is successful, then the 10% deposit will be forwarded to the chargee's lawyer. Okay, that will be remitted to the chargee bank. Next slide. one is land office foreclosure. Okay. So land office foreclosure, the application is slightly different from High Court. Okay, High Court we gone through an OS, originating summons. But in land office, we filed through this form 16G. Okay, it's a prescribed form under the National Land Code too. Okay, so 16G needs to be signed by the chargee's power of attorney. Okay, because usually the power of attorney will be deposited at the respective land office. Okay, if it's, let's say, it's in Mukim, one of the booking, okay, so you have to go to that land office to get the request for particulars of the chargee's PA. Okay, so the chargee PA will tell what is the name of the power of attorney to sign the form 16G. Okay, so when filing form 16G in the land office, it is you must accompany by these few things. Okay, form 16G, form 16D. Okay, prove that you have already served your statutory notice. Okay, this is the condition precedent. Also for land office foreclosure. Then a proof of service that you have served your 16D, usually by way of a statutory declaration. Okay, you have to make an official land search. Official, not non-official, it's official land search. Quick rent. Okay, if it's not paid, get it paid. Okay, the bank usually advance payment, assessment bill, and payment also. Okay. Next slide. Certified true copy of the title and charge. At this point of time, you don't need to deposit original title and charge to the land office yet. Okay, so certified true copy will do, and the application fee for filing 16G. Okay, it differs from land office to land office. Okay, usually it's that's like 300. Okay, with the bank usually provide the lawyers with the bank to file the 16G. Okay, so applicability of land office foreclosure. When the land goes for land office for foreclosure? Okay, this one I already mentioned above. Section 263 of the National Land Code. Okay, provides that the land held under land office title. Okay, then if it's land under land office title, which is M, then you need to go to land office for your foreclosure proceedings to get your order for sale. Okay, upon receiving the 16G, okay, the land office will fix an inquiry date. Okay, so this is provided under section 261 of the National Land Code. Okay, the purpose of that inquiry is for the borrower under the charger to show cause why and order for sale should not be made against it. So this notice of inquiry needs to be served on the chargee and the charger accordingly, and both of them must attend the inquiry. Okay, so the chargee bank can send an to explain what's the outstanding. They will explain to the land administrator who will be hearing the inquiry that they have served and this loan outstanding, and then on the charging side, why they cannot serve service the loan. Okay, what we intend to do. Okay. So that's where the discussion. Okay, so the purpose is not for the charger to show cause why an order for sale should not be made against the property. So at the conclusion of the inquiry, the land administrator shall order for sale of the land if there is no cause to the contrary. But in practice, where the foreclosure and where the charger is present during the inquiry, normally the land office will grant one day, at least one day for them to settle to sort their things out. Okay, but after that, if there's no payment, if it's still defaulting, then the land administrator will have no choice but to order for sale. So the order for sale for land office will be the form 16H. This is also provided under the National Land Code. Okay, so this order will state that the order for sale will state that the sale will be by public auction, and then an auction date will be fixed by the land administrator, usually not less than 1 month from the order for sale, 1 to 2 months. Okay, and what's the outstanding sum? Okay, as at the one date, fix the reserve price. Okay, so the chargee, when they attend the inquiry, they should have their valuation report. Okay, so that the spot, the land administrator can fix the reserve price. Next slide. Okay, so the terms, okay, now I go through the terms of the land office order for sale. We also quite similar to the High Court. Okay, no bidder will allowed to bid unless they deposited 10% of the reserve price with the land office. Then the successful bidder, if they didn't pay full during the auction, then the 10% that they deposit will be forwarded to the charging bank. Okay, so that pending payment, they also have same 120 days also. Okay, okay, so if the successful bidder fails to pay within the completion date of 120 days, then the deposit is to be forfeited, and the property be fixed for fresh auction. Next slide. Okay. So the deposit to be forfeited and money received to be applied by the chargee to pay for the amount due, the outgoing due, okay, and then towards the outstanding sum if there is balance. Okay, so the property should be put to fresh auction. Next slide. So this Form 16H, the order for sale for land office, same. That you still have to serve on the chargee and the charger at least 7 days before the auction date. Okay. So the auctioneer also will liaise with the chargee's lawyer to get their draft declaration of sale approved, and the chargee's lawyer to request from chargee bank original title, okay, similar to the High Court. Okay, get the original title and duplicate charge to be deposited to the land office at least 7 days before the auction date. So on the auction day, it's the same process in the High Court, but land office is still, as far as I know, still manual, okay, unless there are changes. Okay, next slide. Okay, auction can be withdrawn, okay, in the land office, okay, but there is not very last minute. Okay. So before it depends when you want to withdraw the auction. If before the order for sale is out, then you just need to write to the land administrator a letter. Okay, but after the order for sale is out, okay, just before the auction, you want to withdraw, you have to file a Form 16O. The chargee bank will have to file a Form 16O, okay, with the payment, okay, withdrawal fee, usually 3,000. This also depends on land office to land office. Okay, at least 7 days before auction. Okay, so what happens after post auction? Okay, successful auction. Okay, this applies to both. Okay, it's training for both High Court and also land office foreclosure. So lawyer for successful bidder will write to, okay, usually they find a lawyer to act for them. They write to the chargee's lawyer, the bank's lawyer, to confirm the particulars, to request for undertaking, and the chargee to refund loan sum. Okay, so if the land transfer could not be affected, office of outgoing, portion. They will usually, the lawyers for successful bidder will extract all the outgoings and forward to the bank's lawyer for a portion. So the completion date, as I explained just now, is 120 days. Okay, bear in mind, we must ensure. Okay, it's the duty of the successful bidders. Okay, successful bidder and all his lawyer, yes, okay, to ensure that the balance purchase price is paid within 120 days from the bidder. Okay, the balance purchase price must be delivered to the chargee's lawyer. Okay, the chargee's lawyer will, upon receipt of that, will forward the balance purchase price to the bank. Okay, so upon that receipt of the balance purchase price, bank are to issue these two statements. One is to the court and one is to the successful bidder to confirm that they have received the purchase price, full purchase price of the auction property. Okay, this is in the statement, it's like penyatta account. Okay, you file it in court. Okay, next slide. Okay, so this penyatta account has to be filed in court through an affidavit, okay, formed by the chargee bank, and to be filed in court within 30 days from receipt of the full purchase price. This is provided in section 268A, sub 3 of the National Land Code. So affidavit to exhibit the statement of account containing particulars of as follows. Okay, the statement will contain these particulars: the amount of full purchase price, the amount owed by the defendant as at the auction date, and the amount of deposit made to court, 50% one. Okay, payment of the outgoings, okay, bills, okay, quick rent, assessment, auctioneer's fees, okay, that's usually the chargee bank bear that first, okay, and the amount paid towards the outstanding sum after deducting all the other, okay, after deducting all the outgoings. Okay, apart from the penyatta account, the chargee's lawyer also need to file a form 16Q. 16Q is a form prescribed under the National Land Code where it states all the payments due to be deducted from the purchase price. Okay. The particulars will be quite the same as the penyatta account. Okay. The quick rent, assessment, auctioneer's fees, but this is the payment due. Okay. What the chargee has paid, okay. Quick rent, assessment, auctioneer fee, okay, and the deposit to the court. So 16Q is to be served on the charger and the court. Okay, and affidavit of service will prove your service by affidavit of service of 16Q to be filed in court. So successful bidder is to obtain a certificate of in the form of 16F or 16I. Depends, okay. 16F is a certificate of sale for court sale, okay, high court, and 16I is for land office sale, in an office auction. Together with the original title of the ticket charge, then it will subsequently be presented to land office for registration accordingly in favor of the successful bidder. Okay, for land office auction, it is already unsuccessful, okay, for 3 times, more than 3 times. Certificate of reference to court will be issued accordingly. Okay, because land office do not hear more than 3 times. Okay, they will ask you to refer to the court accordingly. So once the chargee receives that certificate of reference to court, okay, you have to file a fresh originating summons in court, just like a fresh. You have to get the order for sale fresh from the court. Okay, that's all for my sharing.
Thank you, Ms. Tan, for the enlightening sharing. I'm sure it is very helpful to many, especially to our attendees today. Now we will proceed to the Q&A session. I would like to share a list of questions that have been posted by attendees before the webinar. The first question is from Mr. Ngai Hock Singh. He asks whether it is true that responsibility of getting vacant possession lies with the person successful in the bidding, i.e. the bankers will not be responsible to grant vacant possession to the buyer.
Yes, that's true.
Okay, the second question is also from Mr. Ngai. He asked whether the successful bidder can rescind his bidding if he fails to secure the loan to buy the property.
Okay, this one I need to clarify again because it's not rescinding. Okay, it's not the purchaser who rescind. Okay, so normally they rescind only when someone report and they rescind. Okay, when someone regulates and they rescind. So as I've explained this earlier during my sharing, if the balance purchase price is not paid within 120 days from the auction date, okay, the auction will be terminated and the property will be put to fresh auction accordingly. No matter it's high court auction or it's land office auction.
The question is from Miss Mary Ann. She asked, how do I stay auction proceedings while appealing against order for sale judgment to the High Court, the Court of Appeal?
Okay, a notice of application. You have to file an application for an order for stay. Okay, after you have filed your appeal to the Court of Appeal.
The next question is from Mr. Devakumaran. He asked whether maintenance fee for stratified properties which are due under the Strata Management Act considered as outgoing.
Yes, but this is, I suppose, this is only for LACA, that means for auctions where the separate title is not issued yet. Okay? Because after title being issued, okay, if there is still maintenance fees, yes, it's still due. Okay, it's considered as due under Strata Management Act.
The next question is also from Ms. N. She asked whether appeal against order for sale to the Court of Appeal is it sufficient to stay the auction proceeding?
No, you have to present special circumstances. Okay? So the fact that you have appealed to the Court of Appeal is not sufficient enough. It's not a good reason. So special circumstances have to be shown.
The last question is from Ms. Serene Key. She asked if the auction is terminated, the bidder will lose the deposit.
Yes, definitely.
Okay. So for the remaining questions, we will answer via email due to the constraint of time. Before we end this session, kindly be informed that an evaluation form will be sent to all of you via email, and we look forward to your feedback on our webinar today. I believe that's all the time we have today. This marks the end of our webinar. Thank you all for joining us.